The construction market, particularly in the UAE, was relatively flat before COVID. It was struggling from liquidity issues brought about by the drop in the oil price, and liquidity is really at the heart of the construction industry. It's how it survives and indeed thrives. There was obviously oversupply as well. Some of the mega projects had been completed, so invariably it meant that there was oversupply of contractors and subcontractors and less work around. When COVID hit, we saw a sort of a calm before the storm, so to speak. There was a general sense of taking stock as to what COVID meant on live projects, and a sense of what it would mean if the pandemic was to continue for a number of weeks and obviously months. That invariably meant companies took stock of where they were from a cash flow perspective, and where they were going to be heading over the next 6 to 9 months. Chiefly because with construction projects in particular, unlike many industries, the projects themselves are stretched over 2 to 3 year periods, and the critical path is determined, and that path can be disrupted, by numerous different events. Obviously, a pandemic of this variety was, I wouldn't say it was unpredictable. There were aspects of it that could have been foreseen, but certainly the global impact it has had on every industry and on individuals themselves and how we operate was probably unpredictable from that perspective. As we got further into COVID and the lockdown continued, although construction in the UAE and around the region was exempt from the COVID restrictions, so work continued on projects on site, chiefly to allow, obviously, that critical path I spoke of not to be too adversely impacted. It's not to say that there was no impact. We saw numerous queries from clients at the very beginning, as you would expect, raising queries of force majeure, whether this triggered certain rights and obligations under the contract. And depending on where you were in the supply chain, we saw various different reactions. Some subcontractors viewed COVID as a sort of silver bullet, a way to excuse previous faults and breaches on their own part, or mask those delays through the use of reference to COVID. Contractors, main contractors, and indeed employers were keen to understand what kind of claims they might be facing, whether their subcontractors were entitled to time but perhaps not cost, and what implications were on them to take action now to try and mitigate that impact both up and down the value chain. Those queries came in thick and fast, and then the market seemed to sort of settle to a degree in terms of what it viewed COVID as. So obviously force majeure was the primary contention, but then focus had turned towards other provisions of the contract, material adverse change provisions, and specifically changes of law. So the provisions under the contract that specified, if there is a material change in the law in the jurisdiction in which you're operating, that will entitle you to certain benefits and indeed certain relief, which was key. So the focus changed, the conversation developed, it became more sophisticated. But as players began to realize that COVID was going to be with us for a considerable period of time, they began to act, take measures to safeguard their own positions. So we saw an increase in the number of letters being written, reserving their position, reserving their rights. But we also saw an increased focus on liquidity. And this came in a couple of different forms. One of the key themes or recurring events over the last 6 weeks has been an increase in the number of bond calls. Obviously quite unique to the construction industry in the Middle East. They're a facet that's been with us for about 30, 40 years. Everyone here who works here is familiar with advance payment bonds, performance bonds, and having one called is not an uncommon event. It should be done in good faith. It should be done on the basis that the other party has made a material breach of the contract or has been terminated, and you're recovering payments rightfully due. But the slightly more sinister aspect of the bond call is that there can also be seen as a way of obtaining substantial liquidity very quickly and then substantiating that call much further down the line. So if you make a bond call for $100 million and it's successful, it's not prevented by an attachment from the court, then you are holding that 100 million for at least 18 months before the substantive dispute addressing whether you were right to call the bond or not has actually been addressed. So we've seen an uptake in that, and then as a result, we've seen an uptake in the number of construction disputes more generally. And I think that's going to be a continuing trend going forward. Force majeure will form a part of future disputes because the pandemic and the outcome of the pandemic, or the causes of the pandemic, were unforeseeable by most reasonable parties. The problem with force majeure is it's the event cannot be force majeure indefinitely. It is an event that was unforeseen. And in the common law, it's a creature of contract. In the civil code and civil code jurisdictions, it's a creature of both contract and of the civil law itself. But it is an event or a series of events that lasts for a prescripted period of time. And therefore, parties have to realize that certainly for new contracts, COVID will no longer be considered a force majeure event. And we're already seeing insurers exclude pandemics and specifically COVID-19 from future insurance contracts. And the same is true of construction contracts. So any new contracts that you're going into, be very mindful of the force majeure provision. Is it being drafted in a way that excludes future pandemics of a similar nature? Alternatively, do you want to, if you're the employer, do you want to try and limit the impact of a pandemic and make it more the contractor or the subcontractor's responsibility? So they will form part of disputes that have arisen in the last 8 to 9 months, but there will only be one aspect of it. The knock-on effect of it will have impacts from a causation perspective on extensions of time and delay, certainly, but the actual event itself of force majeure has come and sort of gone to a large extent. And now parties are having to look at other justifications for changes in their performance. We've seen a maturity of claims. Liquidity is certainly one issue, but liquidity is in some senses the trigger issue that causes the substantive dispute to start. When a party elects to call a bond, then that bond can be attached if it's been called in bad faith by the courts. If the courts do attach the bond, then certainly under UE law, and this is true across most civil law jurisdictions in the MENA region, you have to commence substantive proceedings within 8 days. So the clock effectively starts ticking the minute you get that attachment. And so once you've got it, you've got no option but to go to arbitration or but to go to the courts if you want to maintain the attachment. So where parties were perhaps thinking that they would resolve these matters over time and through potential amicable settlement discussions, bond calls can force the parties into a more litigious setting or a more formal litigious setting than they had previously anticipated. That's not to say that position cannot be put on hold or suspended to allow the parties to come back to the negotiation table. And certainly there are several instances of valid bond calls where parties have not performed and have just withdrawn from the project because of liquidity issues, because of financial constraint on their group companies, in which case the bond in that sense, or the call in that sense, is completely valid. The fundamental starting point is the contract. Always go back to the contract. That is the instruction manual upon which you've agreed to liaise and interact with the other side. So the best way to protect yourself is to review your contractual position and then confirm that position in correspondence. Keeping your credibility is also paramount. If you ultimately end up in a dispute, whether it's before a court or a tribunal, credibility is key. And maintaining that credibility is about putting across clearly that what your contractual position is, that you have complied with it, and that you're not in breach of those obligations. So that's one of the fundamental safeguarding your position. Obviously, it's a vast area, and we obviously don't have time to go into it in too much detail. But safeguarding your position is about looking at your contractual position, but it's also about seeing what you've done on the project already and compiling the requisite correspondence and documentation to ensure that you are ready. You are effectively what we call litigation ready to go to a dispute and either put forward your claim so it's properly substantiated, and or defend any counterclaim that comes your way. And that's about being organized, being on top of the documents, not just the contract, but all the project documentation as well. Construction, the lifeblood of a construction claim is really the documentation. It's probably one of the most overly documented industries in the world. And actually good project managers know this and keep records very, very carefully. And the first protocol should, as I said, be the contract. But if you are encountering a delay, look to see if that's a delay that, first of all, you should and can mitigate. That's always an obligation. As I said at the beginning, COVID-19 and indeed its impact is not, it does not give you the option to sort of put your hands up and say, oh, well, it's altogether too difficult.
Right.
You have to be able to mitigate the delay as much as what is reasonable and what is possible. But look at the contract, see what your legal rights are, look at the notice provisions, make sure that you've notified, whether it be the main contractor or the engineer or the employer, of your contractual entitlements. COVID is obviously, it's a global phenomenon, it's a global pandemic. Everybody is fully understanding of the hardships that many businesses are going through, but don't take that for granted. Right. Your dispute will be dealt with in about possibly 2 to 3 to maybe even 4 years' time, depending on when you choose to bring it, maybe even longer if the project is substantive. So don't assume that everyone's going to have the same level of memory of these events in 4 or 5 years' time when they've come time to review your dispute. Document it very clearly. If there's an event on site or something has happened that's impacted you and it's not your responsibility, clearly document it, notify, and keep detailed records, and keep those records flowing. Obviously, update your program, your Clause 14 program, if one's required. Make sure you know where the critical path is. And if you think this is all building towards a general dispute, which you cannot resolve amicably, then it's at that point that you'll want to consider bringing in external legal counsel to review your position, provide a merits review of your claim and or defense. You may also want to consider claims consultants as well. They're an efficient way of getting an outside third-party assessment of the technical aspects of your claim, both quantification and delay. But ultimately, you'll want to instruct legal counsel to preserve your position, and then potentially, if it becomes necessary, to bring an action on your behalf in either the courts or arbitration.